In this lecture, we shall discuss the composition of the Circuit Courts of Ghana. We shall discuss the composition of the Circuit Courts of Ghana. Now, it is important to note that under Article 126 of the 1992 Constitution of Ghana, the point has been made clear that the judiciary of Ghana shall comprise of the Superior Court of Judicature, which are the Supreme Court, Court of Appeal, High Court, and Regional Tribunals. And Article 126 also mentions that the judiciary shall also consist of such lower courts or tribunals as Parliament may by law establish. Such lower courts or tribunals as Parliament may by law establish. Now, as far as the lower courts and tribunals are concerned, it is important to note that the lower courts or tribunals are all created by an act of Parliament, and they are not created by the Constitution. The Circuit Court is a lower court. It is created by the Court Act of 1993 Act 459. It is not created by the Constitution. So the Circuit Court is a lower court, and it is established by the Court Act of 1993 Act 459. So when you look at Section 39 of the Court Act of 1993 Act 459, it is clearly indicated that the circuit courts are established in Ghana. Section 39 establishes the circuit courts, district courts, and juvenile courts. And they are all established as lower courts. So under Section 39 of the Court Act, the circuit court is one of the lower courts that has been established under the Court Act of 1993 Act 459, Section 39 of the Court Act. It reads as follows, and I quote, "Pursuant to paragraph B of clause 1 of Article 126 of the 1992 Constitution, the following are by this act established as the lower courts." And the first one that is mentioned is the circuit courts. So the circuit court is established as a lower court by Section 39 of the Court Act of 1993, Act 459. Now, it is important to note Section 40 of the Court Act of 1993, Act 459, as far as the circuit court is concerned. Section 40 makes significant statements about the circuit courts. I'll read it, and I shall then explain it. Section 40 will let us know who appoints circuit court judges. It shall also let us know the qualification of a circuit court judge. And so please, let us pay particular attention to Section 40. I'll read the entire provision and I shall explain. Section 40 of the Court Act of 1993, Act 459. It reads as follows, and I quote. Subsection 1. There shall be established in each district. There shall be established in each region. There shall be established in each region the circuit courts that the Chief Justice may determine. Circuit courts that the Chief Justice may determine. Subsection 2. The Chief Justice shall specify the area of jurisdiction of each circuit court. Subsection 3. There shall be assigned to each circuit court a judge who shall be appointed subject to the approval of the President by the Chief Justice, acting on the advice of the Judicial Council. There shall be assigned to each circuit court a judge who shall be appointed subject to the approval of the President by the Chief Justice, acting on the advice of the Judicial Council. Subsection 4. A person shall not be appointed a circuit court judge unless that person is of high moral character and proven integrity and is of not less than 5 years standing as a lawyer. So these are the respective provisions under section 40, and these are the ones I want you to take particular attention to. Pay particular attention to subsection 3 and subsection 4. Subsection 3 deals with who appoints a circuit court judge. It is not the President who appoints. Subsection 40, subsection 3 says that there shall be assigned to each circuit court a judge who shall be appointed subject to the approval of the President by the Chief Justice. So the person who appoints a circuit court judge is the Chief Justice. But the Chief Justice must act on the advice of the Judicial Council. And after the Chief Justice has acted on the advice of the Judicial Council to appoint the circuit court judge, then we shall not gain the approval of the President. So there is the advice of the Judicial Council that will come first. Then the Chief Justice appoints. Then after that, the President approves. So please, when it comes to appointment of a circuit court judge, remember that by virtue of their nature as justices of the lower courts, there is a different procedure that governs how they are appointed. And they are appointed by the Chief Justice, acting on the advice of the Judicial Council and subject to the approval of the President. That is in relation to the appointment of circuit court justices. They shall be appointed by the Chief Justice, acting on the advice of the Judicial Council and subject to the approval of the President. That is as far as the appointment of the circuit court judge is concerned. Now, what is the qualification of a circuit court judge? How many years must you serve as a lawyer before you can be appointed as a circuit court judge? Section 40, subsection 4 of the Courts Act of 1993 at 1259 has the answer. It says that you shall not be appointed as a circuit court judge unless you have high moral character, of proven integrity, and you have not less than 5 years standing as a lawyer. You shall not be appointed a circuit court judge unless you have high moral character, proven integrity, and of not less than 5 years standing as a lawyer. So qualification for appointment to the circuit court: high moral character, proven integrity, and not less than 5 years standing as a lawyer. So we now know the procedure for appointing a circuit court judge. We know that the appointment is done by the Chief Justice, acting on advice of the Judicial Council and subject to the approval of the President. We also know that qualification for appointment as a circuit court judge is that he must be of high moral character, of proven integrity, and of not less than 5 years standing as a lawyer. We also know that the circuit court is a lower court, having been established by Section 39 of the Courts Act of 1993 at 459. Now, by virtue of the fact that they are lower courts, their jurisdiction is conferred by the Act of Parliament. So they cannot exercise jurisdiction that is more than what this Court Act confers on them. So if you look at section 40, subsection 5, it says that a circuit court judge shall exercise the jurisdiction conferred on the circuit court or the judge by this act or any other enactment in respect of causes and matters arising within the relevant area of jurisdiction. And so when it comes to the circuit courts, their jurisdiction is only the one that has been conferred on them by the Court Act. But they can't exercise jurisdiction more than what the Court Act confers on them. Now, finally, some people have wondered that is it possible for a justice of the Supreme Court to come and sit in the circuit courts? Is it possible for a justice of the High Court to come and sit in the circuit court? The answer to that is in section 41 of the Court Act of 1993 as 459. Section 41. And this is what it says, and I quote: without prejudice to subsection 3 of section 40, the Chief Justice or a justice of the Superior Court of Judicature nominated by the Chief Justice may sit as a circuit court judge. Without prejudice to subsection 3 of section 40, the Chief Justice or a justice of the Superior Court of Judicature nominated by the Chief Justice may sit as a circuit court judge. What this means is that, notwithstanding the fact that we have mentioned that the circuit court judge, it is one judge that will preside, we are told that that circuit court judge, even though you are the circuit court judge, the Chief Justice also has the power to nominate a justice of the Superior Court. So be it a justice of the High Court, of the Court of Appeal, or of the Supreme Court, or even the Chief Justice himself. Any of them can be nominated to sit as a circuit court judge. So if you go to the circuit court one day and you see Chief Justice sitting over there, it is not unconstitutional. It is very possible because of section 41 of the Court Act of 1993 at 459, which permits the Chief Justice or a justice of the Superior Court of Judicature nominated by the Chief Justice to sit as a circuit court judge. So at this point, let us do a quick recap of the jurisdiction of the composition of the Circuit Court of Ghana. First, it's important to note that the Circuit Court is a lower court, having been established not by the Constitution, but rather by the Court Act of 1993 at 459. It has been established as a lower court by section 39 of the Court Act. Again, when it comes to the appointment of a circuit court judge, the appointment is done by the Chief Justice, acting on the advice of the Judicial Council and with the approval of the President. Again, as far as the qualification is concerned, a person to be appointed as a circuit court judge must be of high moral character, proven integrity, and of not less than 5 years standing as a lawyer. When it comes to the jurisdiction of the circuit court judge shall exercise the jurisdiction that shall be conferred on that judge by the Court Act. So the circuit court cannot exercise any jurisdiction that exceeds what has been conferred on it by the Court Act or any other enactment in respect of causes and matters arising within the relevant area of its jurisdiction. And also remember that even though we have a circuit court judge that must be at least 5 years standing as a lawyer, section 41 permits the Chief Justice or a justice of the Superior Court of Judicature i.e., the High Court, Court of Appeal, Supreme Court, or any of them nominated by the Chief Justice to sit as a Circuit Court judge. This is where we shall draw the curtains on the composition of the Circuit Courts of Ghana. Thank you.